Yes, I am.
Okay, then we'll go forward in this format. Mr. Rao in a moment is going to put you under oath. In order for him to do that, you'll need to raise your right hand and answer his question. Once you are under oath, it's important that you answer all of his questions truthfully and completely. If at any point you need to speak privately with Mr. Ryan, just let him know, and he will put you guys on mute. You can talk, and then he'll plug us back in, okay?
Doesn't need to talk to me, just let him know.
Oh, okay, yes. Okay.
Okay, great. Mr. Rao, when you're ready.
Carlin, raise your right hand. You swear or affirm that the statements that you provide the court today will be the truth, the whole truth, and nothing but the truth?
Yes.
You know your right hand. And judge, for the record, the defendant is entering a negotiated plea of guilty to counts 7 through 10, which are the only counts she was charged with in the indictment. The negotiated.
Excuse me, Mr. Rao, can you turn on your speaker?
It's on green. You need me to speak up a little bit?
Yes, thank you.
The defendant is pleading guilty to counts 7 through 10 to a negotiated sentence of 5 years on probation. Special conditions of that probation be that she had no contact with the co-defendant who's currently in custody of the Department of Corrections, as well as she be required to complete 100 hours of community service at that time. Ms. Carlin, please tell me your true, correct, and legal name.
Hallie Renee Carlin.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
How old are you and how far have you gone to school?
I'm sorry.
How old are you and how far have you gone to school?
I'm 24. I have a GED and certification in phlebotomy.
Are you able to read, write, and understand the English language?
Yes,
You understand that you're currently charged with the offenses counts 7 through 10. Counts 7 and 8 both being false statements. Each of those carry a minimum 1 year to a maximum 5 years of confinement on each charge. Count 9, hindering the apprehension of a criminal, which carries a minimum 1 year to a maximum 5 years of confinement. And count 10, concealing the death of another, which carries a minimum 1 year to a maximum 10 years in confinement. Do you understand?
yes,
You understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses that you might have if this case went to trial?
yes,
Do you need more time to discuss this case with your attorney?
no, I don't.
Are you satisfied with his services?
Yes,
Counsel, do you waive formal reading of the indictment?
Yes, we do.
Do you waive any and all defects therein?
Yes, we do.
Do you understand, Ms. Carlin, that this is a negotiated plea of guilty, and the state will recommend to the court a sentence of 5 years on probation on each charge to run concurrent to each other? That special condition of that probation is that you have no contact with Darian Flores, and that you complete 100 hours of community service in that time period. But that the court does not have to accept that sentence. The court can sentence you to the maximum on the charge, in the indictment, and run those sentences consecutively or one after the other. You understand that?
yes,
You understand that this plea may be used to enhance sentencing and other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts.
You used an sense of the other charge.
okay, yes,
You understand that if you're currently on probation, your probation may be revoked based on your entering a guilty plea today.
yes,
It's only if you are on probation. I don't believe that you are. Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
yes,
You understand that you're not allowed to possess or use a firearm while on probation?
yes,
You understand that if you are not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation regardless of any advice by your attorney or anyone else.
Yes.
You understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following the trial.
Yes.
Example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transfer a firearm, or the ability to obtain employment.
Yes.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transfer a firearm, you will be guilty of a felony which carries a sentence of 1 to 5 years in prison.
Yes.
And Mr. Ryan, to my understanding that Ms. Carlin wants to take advantage of first offender.
Yes, sir. We'd like to ask the court to allow us to plead pursuant to first offender.
Ms. Carlin, are you asking to be treated as a first offender in the provisions of the First Offender Act?
Yes.
Have you ever pled guilty to or nolo contendere to, or have ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your attorney explained the First Offender Act to you?
Yes.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in the indictment.
Yes.
That if your first offender status would be revoked, you would be considered a convicted felon, and that your guilty plea here today would be permanently recorded on your criminal history. You understand?
Yes.
You understand the waive any and all defenses by entering the plea of guilty today.
Yes.
You understand that by pleading guilty, you were given the following rights: right to a trial by jury, right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney in the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, right to have the charges against you proved beyond a reasonable doubt, and the right to appeal to convicted of these charges after a trial.
Yes.
Does anyone force, threaten, or promise you anything for you to enter a guilty plea today?
I'm sorry.
Anyone force, threaten, or coerce you?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges in indictment number 18 SC 162212? Guilty or not guilty?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Is it freely and voluntarily given?
Yes.
Full understanding?
You understand that you may have only a limited right to appeal this guilty plea conviction.
Eliminated.
Yes.
Do you need me to repeat the question?
No.
No, just a little trouble hearing you, sir. That's all.
Oh, okay. You understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea.
4 years from today for felony and 12 months for rape for misdemeanor.
Okay. Yes.
Your Honor, I believe that concludes the plea colloquy. As far as the factual basis is concerned, the court has heard the majority of it during the plea on December 14th in regards to the co-defendant put on January 14th, 2017 at approximately 12:30 in the morning. The victim, in this case, Elijah Smith, was shot in the back of the head while in Ms. Carlin's vehicle at the hands of the co-defendant at 3190 Old Milton Parkway in Alpharetta, Georgia, which is a quick trip within the jurisdiction of Fulton County. The co-defendant in this case was Ms. Carlin's boyfriend at the time. Ms. Carlin proceeded to reverse her vehicle from the parking lot of the quick trip and then proceeded to drive down south from Alpharetta towards the direction of the city of Atlanta. And then subsequently passing the city of Atlanta, we're ultimately ending up in Jeffersonville, Georgia, which is within the jurisdiction of Twiggs County, where she and the co-defendant in this case disposed of Mr. Smith's body in a wooded area. Ms. Carlin then drove her vehicle back from the from that location to the co-defendant's mother's home, where they picked up the co-defendant's uncle, drove to Ms. Carlin's mother's home in Roswell, Georgia, and proceeded to clean the vehicle that she was using that transported the victim's body, where he ultimately was shot. After that, Ms. Carlin then proceeded to drive her vehicle back to the incident, or back to the location where they disposed of Mr. Smith's body with the co-defendant and his uncle in tow. At some point in time, they separated in Forsyth, Georgia, before ultimately getting to their destination, where they dropped off the disposal of the victim's body. She was then contacted by Officer Vincent San Antonio of the Alpharetta Police Department, as at that point in time a missing persons investigation was underway, as the victim was under the age of under the age of 18 at the time. They contacted her as she was identified as someone who was last seen with the victim at a apartment complex located across the street from the Quick Trip, where she actually was purchasing marijuana from the victim's friend. That friend indicated that Ms. Carlin was the last person to be seen with the victim in this case, and that the victim actually had gone inside the vehicle, I believe, in an effort to purchase cigarillos. She was asked to provide both whereabouts of the victim as well as the co-defendant. She indicated that the last time she saw them was approximately 10 minutes after leaving the Quick Trip, when she came up with the story of the victim leaving the vehicle after an argument between him and the co-defendant in this case, and the co-defendant 10 minutes after that also left the vehicle, and that was the last time that she saw them. Later on that same day, Detective Robinson, who was assigned as the lead investigator in this case, attempted to make contact with Ms. Carlin and was asked to again recite from her memory what had happened prior to her last contact with the victim and co-defendant. She repeated the same story, and it was only until I think approximately 2 days later, that the detective was informed by Ms. Carlin's friend Jessica Alexander that Ms. Carlin later that day had actually confessed to her the real story of what happened, and provided that as an anonymous source to the Alpharetta Police Department. And subsequently, on I believe it was June 16th, 2017, 2 days after the homicide occurred, they executed a search warrant on the vehicles. Excuse me, not a search warrant. They executed a consent search of the vehicles that Ms. Carlin was operating, which was a Lexus, a vehicle registered to her, as well as a Honda CRV, which was actually the incident vehicle where the incident took place. Upon searching that vehicle, they were able to find a defect in the passenger headrest that was consistent with a gunshot, which was consistent with what the friend indicated, that Ms. Carlin indicated to her that the co-defendant had placed a firearm in the back headrest and discharged his firearm. After that, Ms. Carlin then ultimately confessed and indicated that it was the co-defendant that shot the deceased and that she drove away. Ms. Carlin then invoked her right to counsel, as is her right, and it wasn't until approximately 4 years later, when I was assigned the case, that I had the opportunity to conduct a proffer from Ms. Carlin, who was cooperative, and provided us a 3-hour recording of the events that transpired. Ms. Carlin also, approximately 1 week prior to the August 16th trial date, came to the office without her attorney and was willing to cooperate. That's not in any way, shape, or form to indicate that she should be morally absolved of the incident. But she did provide cooperation. I think that does speak volumes about her ability to at least appreciate the gravity nature of the offenses that she's been indicted for, as well as just the actual incident itself. So the state's recommendation in this case based on her cooperation, is 5 years on probation. Her hours community service and no contact.
Okay. Couple questions for you. Do you have a perspective on first offender for Ms. Carter?
No, Judge. I believe that was something that Mr. Ryan indicated. I had no objection.
Is it your understanding from the medical evidence that Mr. Smith would have died immediately, or would he have been alive for part of the trip down to Jeffersonville?
He would have died immediately. There may have been a few seconds after the bullet was launched in his head, but he would have died immediately.
It's not a situation, as you understand it, that if Ms. Carlin had simply driven to the hospital instead of Jeffersonville, Mr. Smith would still be with us.
No,
What steps were taken, as you understand it, to conceal the body? Was it simply dropping it in the woods far away, or did someone dig a big hole and cover it up? Was there different acts?
much of this is, of course, dependent upon Ms. Carlin's statement, as Mr. Flores
Didn't
given.
share with you?
No, Judge. But from what she indicated to Ms. Alexander, and what she indicated to us 4 years later, it appears consistent with her getting out of the vehicle, scoping the area, wooded area that they ultimately disposed the body with. And then her statement to us was that after doing that, she remained in the vehicle, and it's the co-defendant that took the body out of the vehicle and placed it in a wooded area. There is evidence in the form of photographs of, I believe it's Carlin's feet, that indicate that she probably did go into the wooded area, because there were scrapes there that are consistent with this terrain that she would have had to traverse. That is my understanding of, based on what she has indicated to us, what we can prove her involvement.
Okay. Mr. Bonaventura was pretty small. Was Mr. Smith also small?
Yes, he wasn't, I can't
I
remember
understand he was
exactly.
young, but he wasn't 6'4",
No.
250
They were
pounds.
approximately, looked like Mr. Smith was a little bit taller, but as far as weight is concerned, Mr. Smith was a pretty skinny guy. Not particularly, didn't seem like he was particularly heavier than Mr. Flores.
Was it your expectation that Ms. Carlin would have testified at Mr. Bonaventura's trial, or
Yes.
did she merely give you a proffer and wish you the best of luck at trial?
No, Judge, she understood that the purpose of that proffer was to give the state an understanding of what her testimony would be in trial.
Great. Officer Ms. Tucson, do you have any adult criminal history for Ms. Carlin here in Georgia?
No, sir, no record.
All right, Mr. Ryan, I don't want to cut you off partway through your presentation, so what I think I'm going to do is go deal with what I need to and come back, and we will pick up with your presentation on behalf of Ms. Carlin, and then certainly if Ms. Carlin wants to add anything, she's free to do that as well.
Yes, sir.
One last thing, Mr. Rao, anything from Mr. Smith's family? I mean, I think I heard from them when Mr. Bonaventura was sentenced.
I spoke to the victim's mother. She indicated she didn't want to be present for this, but she was made aware on Friday the extent of what was happening today in the state's organization.
Okay, all right. So everyone, please sit tight. I got to go do this thing on my computer at my desk, and then Mr. Ryan, we will turn the microphone over to you, okay?
Yes, sir, Your Honor.
Thanks.
Thanks.
Yeah, if it's typed here, the other question is built on. You could, of course, send them a message asking for some, just to call it. Yes, all I'm asking. The commission will do CS. We'll be able to get rid of that little sheet that has that information, instructions to report, to write all the instructions on. Okay. Congress. They've said becomes 15 minutes already. What to do with this? Ask questions.
All right. All right, Ms. Rivers, are you ready? And can you hear me?
Ready, and I can hear you.
Fantastic. Then let's keep going. I did get to plan out most of, probably won't be Mr. Rao's spring, it'll be Mr. Abate's, but I did get our 6 jury selection dates for the second quarter of 2022. See what happens. But back to this. So Mr. Ryan, you were going to share with me what you wanted to about Ms. Carlin and this case and why first offender and 5 years probation are appropriate.
Yes, sir, Your Honor. Thank you. Your Honor, my client's 24 years old. She was 20 years old at the time of this. She's a single mother of a 8-year-old, 7-year-old little girl. She's got a GED, and she's also, and during this time, been out on bond and received her certificate as a phlebotomist. She lives with her mother in Roswell and her daughter in Roswell, and also helps her mother, who's had some health issues, and she lived there during this time. Your Honor, just briefly, and certainly not to contradict the state in any way, but Ms. Carlin, this was Ms. Carlin's boyfriend, and she was pregnant at the time, or finding out she was pregnant at the time, and she had no idea this gentleman was going to shoot this young man. They were supposed to go and smoke some marijuana. They both bought some marijuana, and they were all getting along and going to smoke, and that's why she went to the Quick Trip to go in to get something to roll the marijuana with, to smoke it. And Mr. Flores shot and killed him in the car, and then threatened her, "You better do what I tell you to do." And she did. She was very much afraid of him. She was young. She did do what the state said. When the police first asked, she did not tell the truth, but she told a friend, who then in turn called the police, and then she did tell them everything and has been cooperative. And also, Judge, she's been cooperative since she got out of jail. We've been through previous ADAs that we've cooperated with and said we were going to cooperate and given proffers to just over the table. But the assistance was not something new with this. He threatened her during that period of time from jail, Mr. Flores, and had people reaching out to her. She subsequently gave that baby up for adoption after she had it. She's a young person, Judge. It's a horrible situation for anyone to be in. She didn't do the right things, but at 20, in the fear of this gentleman, this is what she did. We're asking the court to please accept the terms of the negotiated plea. And I think the state would maybe agree that without her assistance, this case may have been a trial. She certainly cooperated and cooperated consistently over a long period of time, willing to do that. She's young. She's got a daughter to raise and a mother to help who's in bad health. And I would just ask the court to please allow her this opportunity for first offender and the negotiated sentence. I've explained to her the pitfalls of it. And then if she messes up, she's in front of your honor. And then, if she violates, she could be in a great deal of trouble as far as confinement is concerned. But I'd ask the court to please, under mercy and grace, allow her this and allow her to please pursue this plea on this case. Thank you, Your Honor.
All right. Ms. Carlin, anything you want to add?
I don't really know what to say, but I would very much so like the chance to do better, do good things. I made some mistakes, but it's caused me a lot of pain these past few years, and I'm not a bad person, and I really just want to move on with my life and do good for myself, for my daughter, for my family.
How long had you known Mr. Flores at the time this happened?
Maybe like 8 months.
I didn't know, 8 months?
8 months,
8 months.
yes, sir.
Okay. It sounds like you've had 2 kids, one you have with you and one you
Yes, I
put
have,
to adoption, or did I misunderstand, Mr. Ryan?
I have one 6-year-old, by someone else. And I have a 4-year-old that I was given up for adoption, but I still see her and am in her life, but
Okay. So 2 kids total, one with you, one with another family?
yes,
Okay, got it. First offender, Ms. Carlin, is primarily an opportunity. It means that if you successfully complete your probation, you'll have no criminal history. In fact, you'll have no criminal history while you're on probation as well, which is real important in the line of work you're in. If you're trying to go back to school or get a different job, you don't have to check that box on job applications about being a felon. That's the good part, the happy part of it. The risky part, and only you know how risky it is that if you get into meaningful trouble while you're on probation, and I decide that your probation should be revoked, not only could I revoke some probation, but I could decide to take away your first offender status and resentence you because you pled guilty without a trial. You have a hearing and the state would have to prove you violated your probation, but it's a lower standard. And if I found that you had violated your probation, then I would be able to resentence you. And it's a bunch of years that you could be resentenced to. It's not just these 5 years. I could make it 10 or 15 or 20. I don't say that because that's what I would do. It really depends what you did that got you in trouble again. But if you are pretty sure that you are heading in a different direction, you aren't spending time with folks like Mr. Flores or getting yourself in a situation like that, then first offender can make a lot of sense. Do you feel like you understand the benefit of first offender
yes, I do.
and the risk of first offender?
Yes, I do.
Do you want to be treated as a first offender in this case?
Yes,
Mr. Ryan, we are proceeding off of a copy of the indictment. I have a digital copy on my screen here. Do you waive any issues that might arise from proceeding with a copy of the indictment?
Yes, sir, we waive any issues.
Ms. Carlin, if you were here in court, we might pass around the copy of the indictment for you to sign and Mr. Ryan to sign, indicating your guilty plea. But you are not here. Do you authorize me, Ms. Carlin, to sign the indictment for you?
yes,
And Mr. Ryan?
Yes, sir, Your Honor, I do authorize you to sign that.
And Mr. Rao?
Yes,
Okay. Ms. Carlin, I'm going to accept your plea in this case. I find there is a factual basis supporting the claims that you, in 2 instances, lied to the police, first to the officer and then to the lead detective. Also, that conduct led to the police having some additional difficulty figuring out what happened in the case and catching up with Mr. Bonaventura Flores. And just as important, you had a role in concealing Mr. Smith's death by helping scope out the space where Mr. Bonaventura Flores ultimately left the body. Those are all pretty serious. Obviously, more serious is shooting someone in the head, but Mr. Bonaventura is dealing with the consequences of that action. I understand Mr. Ryan's helpful explanation that in some ways you froze up. You didn't freeze because you were doing things like driving the car down to Jeffersonville and finding a spot for Mr. Smith's body. But it does sound like at that point you figured, wisely so, you better do whatever it is that Mr. Bonaventura Flores asks you or tells you to do. It is too bad that you didn't right away go to the police, but that rarely happens. And you were young and this was a scary situation. None of which is a way to say everything is okay. It wasn't okay. Probably not a great idea that you were trying to get some marijuana while you were pregnant. I don't know what else Mr. Bonaventura Flores was up to, but he and his family seemed to pretty quickly figure out how to dispose of a body and clean a car after someone had been shot in it. And I'm hoping that that's not a group you're going to spend a whole lot more time with. But I will follow the recommendation. You ultimately assisted the government in moving forward with the more serious charges against the guy who actually committed the killing. And that's important. It's not easy to do, and it sounds like you were threatened at times not to do so. So I appreciate you making the decision that you felt was right, even though you had some concerns about it. So I will sentence you on count 7 to 5 years, count 8 to 5 years, count 9 to 5 years, and count 10 to 5 years. Those will all be probated. They will all run concurrently with each other. One special condition of your probation will be that you have no contact with Mr. Bonaventura Flores, which should be pretty easy because he's going to be in prison the whole time. But don't write him or call him. If somehow he reaches out to you, you need to not respond to him. And I'm going to give you 250 hours of community service. That's about 1 hour a week for all the weeks you're going to be on probation. And I don't think that's too much given the seriousness of what you got yourself involved with. You do not need to complete them all day 1, week 1, month 1, but you are going to need to make some progress because I'm going to ask probation to let me know if we're getting 3 years into probation and you've done none. You're setting yourself up to have some trouble knocking out all that community service. So you want to think about a place that is meaningful and easy for you to get to do community service. It doesn't need to be picking up trash on the side of the road. It can be working with little kids or wherever the organization you find thinks it's appropriate for you to give back to the community. So I am sentencing you pursuant to the Probation Options Management Act. And all that means, Carla, is that if you have a small problem on probation, you and probation can work through that. If you missed a meeting or something like that, you don't have to come see me. But if you're ever arrested again, that type of violation comes back to me while you are on probation. Mr. Rao, anything else in Ms. Carlin's case? Mr. Ryan, any questions about the sentence that I've imposed?
No, sir, Your Honor.
Ms. Carlin, you think you understand it?
Yes, sir.
So it is a first offender sentence. So you are not convicted of anything right now. You are a first offender probationer. Let me find out, Officer Tucson, Ms. Tucson, did you get, I know you got contact information for Mr. Ryan. Is that how you and he are going to exchange reporting instructions?
That's correct. I'm gonna get his email and just email him a copy of the reporting instructions.
Okay.
And obtain all of her information as well.
Fantastic. So, Mr. Ryan, you as Ms. Carlin's lawyer will get the reporting information for Ms. Carlin. Ms. Carlin, real important date coming up, and it's in the next few days. You got to report to probation to establish that initial contact with probation and figure out who your supervising officer is going to be. Okay?
Okay.
All right, and if you have any questions about it, ask Mr. Ryan. If he can't get you answers, he'll know to reach out to my staff and we'll figure it out. But he shared here in the chat his contact information so that Ms. Tucson can reach out.
Okay.
All right, I think that's it. Thank you, everyone.
Thank you, Your Honor. May I be excused?
Yes, you may. Thank
Thank you,
you.
Mr. Rao. Thank you.
All right, thank you, Ms. Rivers and Ms. Nelson. I will see you all virtually someday.
All right, thank you.
Bye-bye.